Hello, everyone. Welcome back to Vector Ratio, your international law channel created by me, Professor Natalia França, and Professor Flavio Bastos. Today, we're going to tackle one of the most important issues in public international law in order to understand the conflict, apparent or not, between international treaties and internal rules of states. We speak, therefore, of monist and dualist theories and their aspects. From the moment that international law began to be understood as such, that is, with the abandonment of the belief that in international field there were only customs, good practices, and voluntarism of states, and that a true international legal system was being created, theories of how those two worlds, international and internal, are legally related to each other began to be discussed. Reluctant to the advancement of an international legal system, we have the dualist theory by Triple and Anzilotti, for example, which understands that the objectives of international law and the domestic law of states are totally different, since they are legal systems produced in a different way and they are mutually exclusive, as if there was a radical line dividing between the two of them. For this theory, both systems are equally existent and valid, but they have different sources, they have different objects and different goals. In international law, its source is the treaty, the accommodation of at least two sovereign wills, while in domestic law, the source is the will of a single state. In the same way, the sources and norms of international law do not influence matters of domestic law and vice versa. Only one applies to the outside and the other only applies to the inside. Still, the dualist theory believes that the assumption of an external commitment does not have any impact or repercussion on the domestic law of the countries, but only for the relationship between two or more countries. In order for the international norm to have a legal value internally, the state needs to transform it into an internal norm, whether by an amendment, an act, a decree, regulation, in short, some time of incorporation, since the mere ratification, the signing of a treaty, is not enough. There has been there has to be a reception by the internal mechanisms. Finally, the dualist theory, the state in the dualist theory, the state initially refuses the applicability of international law, putting an internal filter to comply with its rules. There is no mention of conflict between international and internal norms because within the country, the internal law is applied, whether it arises from the parliament or an international norm formally internalized. Treaties are just commitments outside the state. They are only valid, therefore, within the country when formally transformed into domestic law. There is a subdivision of the dualistic theory. The radical dualistic theory preaches the need to issue a separate law for the incorporation of a treaty into the national legal order. This is what Triple believes, for example. And the moderate dualist theory says that the incorporation of a treaty into domestic order does not require an act, although it is done through a complex procedure with the approval of the parliament and the promulgation of the executive power, such as the president or prime minister. We now move on to the monistic theory, according to which the law is one, and international law and domestic law are two branches of a single legal system. After all, both are produced by the state, whether there are commitments made with other states or norms for their administered people in the domestic order. According to this belief, international law applies directly to the legal order of states, regardless of any formal transformation or incorporation, since the manifestation of sovereignty has already been given when the treaty was ratified. Both international law and domestic law would be able to govern the legal relationship of individuals. Signing and ratifying a treaty means assuming a legal commitment. If the treaty includes rights and obligations that can be demanded domestically, it is not necessary to issue a new normative diploma to materialize such obligations at the domestic level. ratification already generates effects at the national level. It is a relationship of genus and species. Domestic law integrates international law, depriving it of its logical validity. They are concentric circles, where the largest represents international law and the smallest within domestic law. There are matters that fall under the exclusive jurisdiction of international law, but the same is not true for domestic law. For monism, the foreign commitments assumed by the states are not bravado, empty promises of diplomats, but they have immediate application in the internal order of the country that agrees, which reflects the system of automatic incorporation. The problem that arises, however, is that of hierarchy in case of conflict of norms. If both are part of the same system, which one prevails when there is a conflict between an internal norm and an international norm? Hence, we have a subdivision of the monist theory. Firstly, the nationalist monist theory, or the monist theory with domestic law first, says that the domestic norm will always prevail. Full stop. Secondly, the monist internationalist theory, or a monist theory with the primacy of international law, which can be radical, like Kelsen's, believes that international law always prevails, even with the nullity of domestic law if applicable. Or moderate, like Werdross, for whom there is no nullity and there is a case in which the internal norm prevails over international law, when the international norm contradicts the fundamental law of the nation, usually the Constitution. That is why this aspect is called moderate. Well, that was it. I hope you enjoyed today's video, and more importantly, hope that you understood these two important theories of international law. See you later in our next video. Bye.